Applicable law. Contracts for the sale of tangible goods are governed by Article 2 of the Uniform Commercial Code. All other contracts, such as those for services or real property, are governed by the common law. Valid contract. In order to bring a successful breach of contract claim, there must first be a showing of a valid contract. To form a valid contract, there must be an offer, acceptance, and consideration. Additionally, there must be no grounds for a valid defense to formation. 1. Mutual assent. Parties to a contract must manifest mutual assent to be parties to the contract. This is typically shown through offer and acceptance. 2. Consideration. Consideration is necessary for there to be a valid contract. Typically, a showing of consideration is done by facts evidencing the parties have obtained a legal benefit or detriment through the contract. Some states, however, only look to legal detriment. Mutual mistake. A mutual mistake occurs when both parties have a belief not in accord with the facts as to a material fact underlying the contract which causes a material change in performance of the contract and for which neither party held the risk of mistake. Plain meaning. Generally, when a court examines what is required under the contract, it looks to the plain meaning of the words therein. Traditionally, a court could not examine any extrinsic evidence to give meaning to those terms unless they were ambiguous. Trade usage. Thus, a court could consider this trade usage in determining the scope of S's obligations. Because there is no evidence of course of performance or course of dealings between S and Barn, this would be the most dispositive evidence as to S's obligations. Modification. Under the common law, a good faith modification requires consideration to be valid. Here, Barn may argue that even if paint is not deemed to include surface preparation, the parties modified the contract after it was formed. Parole evidence. Under the parole evidence rule, when there is a written contract, the parties may generally not present evidence of prior or contemporaneous agreements made before the writing. If the writing is meant to be the full and final expression of the parties' agreement, then no extrinsic evidence is permitted absent a finding that the term would have been naturally omitted. The contract is said to be a complete integration. If, instead, the writing is simply part of the full agreement, then only extrinsic evidence that does not contradict the written terms may be admitted. Such a writing is said to be a partial integration. Merger clause. Firstly, there is no merger clause, which indicates that the agreement is the final and complete expression of the parties' contract. Breach. When a party fails to perform as contemplated by the contract, there has been a breach. However, a breach does not necessarily excuse the other party's obligation to perform. When there has been substantial performance, i.e., the non-breaching party has received the substantial benefit of its bargain, the non-breaching party must still perform its obligations under the contract. Only when there has not been substantial performance will the obligations of the non-breaching party be suspended. Expectation damages. Expectation damages are the default damages in contract. They are meant to place the non-breaching party in the same position it would be in had the breaching party performed. Consequential damages. Consequential damages are those that arise as a result of the breach that are foreseeable to the parties, either expressly or when the parties contemplated the contract, caused by the breach and reasonably certain. Incidental damages. Incidental damages are those damages that flow from the breach. This includes damages for expenses incurred to inspect goods, ship back non-conforming goods, or to warehouse non-conforming goods. H. Unjust enrichment, restitution. Restitution is available when a plaintiff confers a benefit to the defendant without gratuitous intent, and it would be unjust to allow the defendant to keep that benefit without compensation. Restitution can be calculated either by the value of the benefit conferred on the defendant or the cost to the plaintiff in conferring that benefit. Duty to mitigate. When a plaintiff suffers a breach, they have a duty to mitigate their damages. Specific performance. Specific performance is an equitable remedy available to a non-breaching party that would order the breaching party to perform on the K, specific performance is only appropriate where there is an inadequacy of legal remedies, the non-breaching party complied with any conditions to performance they were required to and were ready to perform, and enforcement of specific performance is feasible. Specific performance is only available on contracts for the sale of land, or for the sale of goods that are rare or unique. Specific performance is never an available remedy on a services contract. Inadequacy of legal remedy. Specific performance is typically a rare remedy in contract. For most contracts, damages will be sufficient. Specific performance because courts are loath to award such relief in services contracts. Such a remedy would likely amount to indentured servitude in violation of the 13th Amendment. Laches. Laches occurs when the defendant unreasonably delays bringing suit, and that delay prejudices the plaintiff. Unclean hands. Unclean hands occurs when the plaintiff has engaged in immoral or otherwise inappropriate behavior in relation to the contract. Governing law. The UCC governs contracts for the sales of goods. The common law governs contracts for services, the sale of land, and all others not under the UCC. Contract formalities. A valid contract requires 1. Offer, 2. Acceptance, and 3. Consideration. Further, a land sale contract must be in writing to satisfy the Statute of Frauds, SOF. Breach of contract. A breach of contract occurs when one of the parties fails to perform on the contract. With land sale contracts, once the conveyance is made, it extinguishes the contract, and the parties can only sue on the deed, and based on which future covenants were granted in the deed, further assurances, quiet enjoyment, or warranty. Fraud. Fraud requires 1. A misrepresentation, 2. Of material fact, 3. Known to induce reliance, 4. Actual reliance, and 5. Damages. A misrepresentation does not have to be a lie, but can be an omission as well, if the seller knew of the defect and failed to inform the buyer of the defect. Rescission. A contract can be rescinded based on a mutual mistake or fraud. Reliance. Reliance damages can be obtained to avoid any unjust enrichment on the part of the defendant. Reliance seeks to put the non-breaching party in the position as if there had been no contract. It would be unfair to rescind the contract and return the condo to Steve with $22,000 worth of improvements. Expectation. Expectation damages seek to put the non-breaching party in the same position as if no breach had occurred. Incidental. Incidental damages are those damages that the non-breaching party incurs as a result of the breach. Punitive damages. Punitive damages seek to punish the defendant for willful and wanton misconduct. Generally, punitive damages are not awarded for breach of contract actions. However, a plaintiff may recover punitive damages if there is an underlying tort. Limitations on damages. Damages must be causal, certain, foreseeable, and mitigated. Parole Evidence Rule. The Parole Evidence Rule, PER, seeks to prohibit prior oral negotiations of a contract because the parties intended to put their final expression in the writing itself. During negotiations, Steve told Betty that there was no deeded parking, but she would be allowed to park on an adjacent lot for $50 per month, just as he had. Steve will argue that because such communications were oral and prior to the final contract, that the court should exclude them. This defense will fail because his actions constituted fraud, and the contract had already been performed. Laches. Laches seeks to bar a plaintiff's recovery if they wait too long to assert a claim, and such delay of time causes an undue prejudice to the defendant. Unclean hands. The Court of Equity will not aid suitors who come to the court with unclean hands. Temporary restraining order. A temporary restraining order, TRO, is an order granted in equity that preserves the status quo until a preliminary hearing on the matter can be heard. They are generally granted in emergency situations. For a TRO to be granted, the party seeking the TRO must show 1. Irreparable harm will occur in the absence of awarding the TRO, 2. Balance of hardships favors granting the TRO, and 3. The party seeking the TRO is likely to prevail on the merits. While a TRO may be granted ex parte, without opposing counsel's presence, courts will generally requiring a strong showing of a good faith effort to notify the opposing party, or a strong showing of why notice could not be effectuated. TROs are awarded for a short duration, typically 10 to 14 days, depending on the jurisdiction. Some courts also require a showing that damages are inadequate. Preliminary injunction. Similar to a TRO, a preliminary injunction is an injunction issued to preserve the status quo until a full hearing on the merits can be had granted by equity courts. In addition to the elements of the TRO, irreparable injury, balance of hardships, likelihood to prevail on the merits, and in some jurisdictions, inadequate legal remedies, in order for a preliminary injunction to be granted, the opposing party must have notice and an opportunity to be heard at the hearing, and no defenses may apply. Additionally, the court may require the plaintiff, here, Rick, to post a bond in case Rick is ultimately not successful in his claim for specific performance. Unclean hands. Unclean hands is an equitable defense. Under this defense, a plaintiff who acted unfairly with respect to the current action will be barred from recovery, because they too have unclean hands. Laches. Laches is another equitable remedy, in which case the plaintiff's unreasonable delay in bringing a claim caused substantial prejudice to the defendant. Applicable law. The contract at issue is an insurance contract. UCC Article 2 governs sale of goods. All other contracts are governed by the common law. Accordingly, the common law would control. Rescission. The remedy of rescission allows the party asserting rescission to avoid its obligations under the contract. Rescission is allowed if there is a valid basis for rescission, and there are no valid defenses. The remedy of rescission is meant to cure a problem that occurred during contract formation. Typical bases for rescission include mutual mistake, unilateral mistake, fraudulent misrepresentation, misrepresentation of a material fact, even if not fraudulent, and ambiguous terms in the contract that neither party understood. Misrepresentation. Misrepresentation occurs when one party, I, states a fact to the other party, 2, the fact turns out to be false, 3, the other party relied on the false statement when agreeing to enter the contract, and 4, the party making the false statement either did so fraudulently, or the statement involved a material part of the contract, i.e., even if the statement was not made fraudulently, if it involved a material fact, that is still enough to make out a claim of misrepresentation. Mutual mistake. Mutual mistake occurs when both parties to a contract made a mistake regarding a material term of the contract on which the contract was based. For a party to successfully assert mutual mistake, that party must not have assumed the risk of the mistake occurring. Unilateral mistake. Unilateral mistake can serve as a basis for rescission when one party made a mistake in the contract formation that the other party knew or should have known about. In unilateral mistake, the negligence of the party that made the mistake is not a defense to rescission of the contract. Equitable defenses. Rescission is an equitable remedy, so equitable defenses apply. The defenses of unclean hands and laches are the most common. Unclean hands refers to the plaintiff taking inequitable actions regarding the contract itself. Laches refers to an unreasonable delay in bringing a claim that prejudices the defendant. Reformation. For reformation to be available, there must be a valid contract, grounds for reformation, and no valid defense. Reformation is typically ordered in situations where both parties agreed to certain terms of the contract, and those terms did not end up in the finalized contract due to an error such as a Scrivener's error. Parole evidence. Under the parole evidence rule, if there is a final, fully integrated contract, then any communications regarding the contract terms that contradict or supplement the contract either before or contemporaneous with the contract being finalized are inadmissible. Equitable remedies. Remedies are ordinarily split into two categories, equitable remedies and remedies at law. Equitable remedies are only available where a remedy at law is inadequate to repair the harm. Equitable remedies are decided by the judge, whereas legal remedies are usually decided by a jury. Unlike legal remedies that usually only declare damages owed from the defendant to the plaintiff, equitable remedies are backed by the contempt power of the court. If a defendant fails to comply with an equitable order, she can be held personally in contempt of court. Temporary Restraining Order, TRO. A temporary restraining order is a stopgap measure wherein a court can order a defendant not to act, or occasionally to act affirmatively, in order to preserve the status quo until a hearing on a preliminary restraining order can be heard. A temporary restraining order will only be granted where the plaintiff can demonstrate that 1. She will suffer irreparable harm without the order. 2. The balance of the equities between the plaintiff and defendant favors the order. 3. The plaintiff is likely to prevail on the merits of her claim. A temporary restraining order can be heard ex parte if the plaintiff demonstrates a good faith attempt to give notice, or demonstrates good cause for not giving notice. A temporary restraining order is a time-limited measure, typically limited to 10 days. Preliminary injunction. A preliminary injunction is a longer-lasting prejudgment equitable remedy. A preliminary injunction is a court order restraining the defendant from action, or more rarely, requiring the defendant to affirmatively act, to preserve the status quo. It lasts until there is a final judgment on the merits. The requirements for a preliminary injunction are identical to those for a temporary restraining order. 1. Irreparable harm. 2. Balance of the equities. And 3. Likelihood of success on the merits. However, a preliminary injunction requires notice to the defendant and a hearing. Contract reformation. Contract reformation is an equitable remedy wherein the court will correct an error in a written contract in order to conform the contract with the actual agreement of the parties. Reformation is most often available where there is an error in the contract on the basis of a mutual mistake or Scrivener's error. Mutual mistake. A mutual mistake occurs where both parties intend the contract to reflect an agreement between them, but, due to a mistake by both parties, the contract does not properly reflect this agreement. Specific performance. Specific performance requires the defendant to actually perform under the contract rather than pay legal damages for the breach. Specific performance is available where there is 1. A valid contract. 2. That is sufficiently definite in its terms. 3. All conditions have been met for defendant's performance. 4. That there is no adequate remedy at law. 5. Enforcement is feasible. And 6. It is not subject to any equitable defenses. Courts are hesitant to grant specific performance for repeated transactions, and will never allow specific performance for personal services. Expectation damages. A land buyer's legal remedy for the seller's breach of contract is ordinarily expectation damages. Expectation damages seek to put a non-breaching party in the same position they would be in but for the breach. In land sale contracts, they are calculated by the difference in the fair market value of the land and the contract price for the land. Consequential damages. Consequential damages that arise from the breach if they were reasonably foreseeable. Any lost profits claim would be limited by a defense of foreseeability and reasonable certainty. Reliance damages. Where a buyer is unable to prove expectation damages, perhaps because the market price is below the contract price, a buyer can seek reliance damages for the breach. Reliance damages seek to put the buyer in the same place she was before the contract was made. Most often in land sale contracts, the reliance damages are the out-of-pocket expenses, including any down payment or earnest money paid to the seller. Where a seller breaches in good faith, for example, because he is unable to deliver marketable title due to no fault of his own, a buyer may also be limited to her reliance damages. Restitution damages. Finally, restitution damages are available where other remedies are inappropriate and inadequate, and the defendant has been unjustly enriched by this action. Rescission. There must be grounds for the rescission, and no defenses preventing it. A material misrepresentation is grounds for rescission if the seller made a misrepresentation of a fact that a reasonable buyer would have relied on, and the buyer did in fact rely on the statements. While generally the doctrine of caveat emptor applies to omissions, there is implied in every land contract a duty not to make material misrepresentations. Generally, the failure to mention a material fact is not actionable, though in some instances a court may hold the seller liable for known latent defects. Compensatory damages. Compensatory damages aim to make the plaintiff whole, to put them in the position they would have been in had the contract been fully and properly performed. Consequential damages are those damages specific to the plaintiff that were foreseeable at the time the contract was entered. Incidental costs are those associated with dealing with the breach. Punitive damages. Punitive damages are not awarded in contracts claims. However, C's misrepresentations likely raise to the level of fraud and are thus actionable under tort law. In that case, C may be liable for penal damages for fraud. Restitutionary damages. Alternatively, A may recover restitutionary damages from C. Restitutionary damages seek to prevent the defendant from being unjustly enriched. The plaintiff may recover the reasonable value of the benefit received by the defendant. Note that A may not recover both compensatory and restitutionary damages, and thus will likely elect compensatory as the larger amount of damages. Constructive Trust / Equitable Lien. I may get a constructive trust or an equitable lien over the compensatory or restitutionary money damages due to her. Intentional misrepresentation. Fraud is the intentional misrepresentation of a past or present fact, made with the intent that the other rely on it, and the other does reasonably rely. Punitive damages. If a defendant acts wantonly, willfully, or maliciously, the plaintiff may also recover punitive damages as long as she recovers either compensatory or nominal damages as well, and sometimes restitutionary. Punitive damages seek to punish the defendant for his willful wrongdoing. Constructive trust. A constructive trust is a court order that the defendant hold the property in trust for the benefit of the plaintiff and return the property to the plaintiff, along with any enhanced value. If the property is no longer available, but may be traced to another form, as long as it can be traced with certainty, the plaintiff may still recover the value of the property by tracing. Equitable lien. An equitable lien is a court-imposed security interest in the property, which must be sold, and the proceeds returned to the plaintiff. If the sale results in less money than is owed, the plaintiff may get a deficiency judgment and a lien on the defendant's other property to secure that judgment. However, the plaintiff may not recover any enhanced value in the property. Tracing may also be used to ensure return of the property. Contract law. Common law. In contract law, the common law governs service contracts or land sale contracts, and the UCC governs the sale of goods. This is relevant because there are certain differences in remedies between the two areas of law, and certain remedies that are specific to the UCC. Expectation damages. The default contract remedy is expectations damages. Expectation damages seek to place the non-breaching party in the same position he or she would have been in had the breaching party performed. Said another way, expectation damages seek to give the non-breaching party the benefit of its initial bargain. The general formula for expectation damages is the difference amount of price, or the amount to be paid for a service or good under the contract, and the amount of replacing, the market price, it, plus any incidental damages, plus any foreseeable consequential damages, less any amount saved by the non-breaching party. Consequential damages. Lost contract with TAMI. Consequential damages are damages that are unique to an individual party, i.e. they are not those that are clearly within the contract, such as the contract price, but that are the natural and foreseeable consequences of a contract breach, or are contemplated by the parties when contracting. Importantly, to collect consequential damages, the damages must be proven with reasonable certainty, and they must be foreseeable. Incidental damages. Incidental damages are naturally arising damages that a party incurs when trying to fix the situation after another party breaches. Incidental damages include costs such as trying to renegotiate other deals. Mitigation. A non-breaching party has a duty to mitigate damages by seeking reasonable replacements or substitutes for goods or services. Lost volume seller. A party does not need to reduce expectation damages by the cost of cover or replacement performance if the party is a lost volume seller. Generally, this applies to sellers of goods who have enough supplies to meet the demands of their customers, such that the other party breaching does not just allow the seller to sell to a new party, but the breaching party merely constitutes a lost sale the seller could have met anyways. If a party is a lost volume seller, cover or replacement service will not reduce its damages. Reliance. Reliance damages seek to place the non-breaching party in the position he or she would have been in if the party had never entered into a contract. Thus, reliance damages generally consist of reasonable expenses the non-breaching party has incurred in preparing and partially performing the contract. However, a party may not collect both expectation and reliance damages. Restitution. Restitutionary damages seek to compensate the non-breaching party for benefits he has conferred on the breaching party in order to prevent unjust enrichment by the breaching party. In some circumstances, a breaching party may even be able to collect restitutionary damages if he has substantially performed and thus conferred a substantial benefit on the other party. Restitutionary damages may take the form of either the amount of improvement the breaching party has enjoyed or the value of the services provided by the non-breaching party. Courts have equitable power to choose one or the other and will consider factors such as the blameworthiness of the parties. Specific performance. It is within a court's equitable powers to grant specific performance as a remedy in certain circumstances. Specific performance requires that both parties actually complete the contract, rather than compensate each other in money for any breach. Specific performance requires 1. A valid contract, 2. With clear provisions that can be enforced, 3. An inadequate legal remedy, i.e. money damages are insufficient for some reason, such as the good or service is unique, 4. Balancing the hardships, performance is equitable, and 5. Enforcing the performance is feasible. Constructive Trust. A constructive trust is an equitable remedy whereby a court requires a person who wrongfully acquired title to property to hold that property as a forced trustee and to return it to its rightful owner. Although it will not defeat a bona fide purchaser, it does allow tracing. Moreover, a constructive trust will allow a person to recover any increase in value of the property. This remedy is generally only allowed when money damages would be inadequate. Conversion remedy. Under general tort recovery from conversion, the individual is entitled to receive the market value of the item that was converted at the time it was converted. Equitable lien. An equitable lien is also an equitable remedy whereby a person who acquires the personal property of another can have a court put a lien on that property. This remedy is appropriate where the defendant misappropriated the plaintiff's property under circumstances giving rise to a debt or obligation owed to the plaintiff. The property can be traced to the defendant, and the defendant's retention of the property would result in unjust enrichment. Like the constructive trust, the defendant can trace the property to another form as long as the residential can be identified. However, unlike the constructive trust, the plaintiffs are not entitled to any increase in value in the property under an equitable lien. Restitution. Restitution is a remedy that is available to prevent a party from being unjustly enriched at the expense of another. Laches. Laches is a defense that arises because a party takes such a long time to bring a cause of action that it materially prejudices the opposing party. Statute of Frauds. The Statute of Frauds is a defense that a party cannot assert to prevent a claim that a contract existed. It is applicable to an alleged contract to purchase or sell land, which must be in writing, signed by the grantor, and include a purchase price. Unclean hands. The doctrine of unclean hands applies, especially in the equity context, to prevent a party from recovering where that party was involved in bad behavior relating to the underlying transaction. License. A license is a permission to use another's land in a particular way. A license need not be in writing or evidence any of the formalities of an easement. However, a license is freely revocable. Importantly, a licensee may only act within the scope of the license. Where a licensee exceeds the scope of his license, he trespasses on the land. Trespass to land. Trespass to land occurs when an individual intentionally invades the real property of another. The trespasser need not know the land is not his own, he need only intend to go where he goes or do what he does. Another important aspect of the rule is that trespass can occur with more than just the trespasser's body. When a trespasser causes a physical object to go onto the land of another, he has trespassed, even if his body does not actually break the relevant plane. Actual cause. A tort is an actual cause of damages when the damage would not have caused but for the tort. Proximate cause. A tortfeasor is only liable for those damages that are proximately caused by his tort. Proximate cause is a question of foreseeability, where the result is a foreseeable result of the actions of the tortfeasor. At the point where the damages become unforeseeable, law is willing to cut off liability and let the damages fall on the victim. Restitutionary remedies. Restitution is appropriate where the tortfeasor has been unjustly enriched by his activities. Ejectment. Another possible remedy is ejectment. Ejectment allows a person in rightful possession of land to eject a trespasser who is present on his land. This action is only appropriate where the trespasser is still on the land. Trespass to chattel and conversion. Trespass to chattel occurs when someone intentionally interferes with the possessor right to another's chattel. This can occur in two ways. The trespasser can actually deprive the owner of the chattel temporarily or permanently, or the trespasser can cause damage to the chattel. Conversion consists of the trespass to another's chattel that so interferes with his right to possession that the owner is entitled to a replacement of the chattel. Essentially, this is a forced sale, where the tortfeasor has to pay the reasonable market price of the chattel. Punitive damages. Punitive damages have three requirements. There must be actual damages awarded, the punitives must be proportional to the actual damages, and the conduct must be more than negligent. Governing law. The UCC governs contracts involving the sale of goods. Contracts which are for services, or are land contracts, are governed by the common law. Valid contract. For a contract to be valid, it must contain offer, acceptance, and consideration. An offer is an outward manifestation by the offeror that creates the power of acceptance in the offeree. An advertisement can be a valid offer as it is made to a particular person, outlines the specific details of the offer, and presents the recipient of the advertisement with instructions as to how acceptance can be made. Acceptance is an outward manifestation by the offeree that he accepts the terms of the offeror. Acceptance must mirror the terms of the offer. If acceptance does not mirror the terms of the offer or, in itself, alters the terms of the offer, it is a counteroffer and effectively rejects the original offer. However, a mere inquiry is not a counteroffer. Consideration is a bargain for legal detriment. Modification. Under the common law, a modification to a contract must be supported by consideration. The pre-existing duty rule prohibits the modification of any contractual duties which have been agreed to absent consideration, because the party is attempting to modify something that he/she is currently obligated to do. Statute of Frauds. The SOF requires that certain contracts be in writing. The categories are contracts regarding marriage, contracts which cannot be performed within 1 year, land sale contracts, executor agreements, guarantees, or suretyships, and contracts for the sale of goods for over $500. A contract which cannot be performed within 1 year is determined at the time of the contract execution, and is measured by whether there is any possibility performance can be completed within 1 year. The writing that will satisfy the SOF must contain the essential terms of the contract and be signed by the party to be charged. Estoppel and likely partial performance to the SOF requirements. As stated above, certain writings are subject to the SOF. There are 4 defenses to the enforcement of the SOF. 1. Partial or full performance. 2. Estoppel. 3. Judicial acknowledgement of contract. And 4. Merchant's confirmation memo. Partial or full performance. A party may not comply with the requirements of the SOF if he partially or fully performs his contract, and the other party accepts the benefits of the performance. Equitable estoppel. A party may not comply with the requirements of the SOF if he can assert a defense of estoppel. Equitable estoppel occurs when a party says or does something that foreseeably creates action in another person. The other person relies on the party's previous statement or action, and it would be unjustly prejudicial to the relying party. Expectation damages. Expectation damages place the plaintiff in the position he would have been in had the breaching party performed the contract in full, including any incidental and consequential damages that are reasonably foreseeable from D's breach. Reliance damages. Reliance damages place the plaintiff in the place he would have been had the contract not existed. Restitution. Restitution damages reimburse the plaintiff for any benefit conferred on the defendant. A plaintiff cannot receive restitutionary remedies if they receive expectation damages. Mitigate damages. A plaintiff always has the duty to mitigate damages and, in the employment context, the duty to find other employment. The plaintiff is not required to find any job, but rather a job comparable to the job that has been taken. If a plaintiff cannot find replacement employment, a good faith effort must take place to find employment. Specific performance. Specific performance is available when the contract has definite and certain terms, there is an inadequate legal remedy, the court can correctly adjudicate, there is mutuality between the parties, and there are no defenses. Inadequate legal remedy applies when you are dealing with land or unique items. Mutuality has been relaxed and no longer requires that the parties must each be able to get specific performance. Just that the party is ready and willing to perform. Specific performance will not be applied to a services contract because it is difficult to enforce and can abridge certain constitutional provisions against servitude. Governing law. Contracts for goods, that is, tangible movable items, are governed by Article 2 of the Uniform Commercial Code. All other contracts, including contracts for the sale of real property, are governed by the common law. Where a contract covers both goods and real property, courts look at the primary purpose of the contract to determine whether the UCC or the common law applies. Formation. A valid contract requires mutual assent in the form of an offer and acceptance and bargained for consideration. Offer. To be valid, an offer must be directed to a particular offeree and contain the essential terms of the deal. Under the common law, the essential terms are the parties, the subject matter, the quantity, and the price. Acceptance. A party accepts an offer by objectively manifesting an intent to be bound by the terms of the offer. Consideration. Consideration is bargained for legal benefit or detriment. Courts do not typically look to the value of the consideration. Reformation of Contract. Where a contract is based on the mistake of one party, sometimes the party may seek reformation of the contract to correct the mistake. Reformation is an equitable remedy that courts provide when a party has shown the elements of unilateral mistake. When a party successfully seeks reformation, the court will rewrite a contract in order to conform to the party's intent sans the mistake. Unilateral mistake. To persuade a court to reform a contract based on a unilateral mistake, the plaintiff must show the following. 1. That the plaintiff was mistaken about the terms of the contract. 2. That the mistake went to a material term that was a basic assumption of the contract. 3. That the defendant party knew of the plaintiff's mistake. And 4. The defendant failed to correct the mistake or even took advantage of the mistake. To be material, the mistake must be about an issue that affected whether the parties would agree to enter into the contract. Fraud. A party commits fraud when, with scienter, he lies about a material term of a contract in order to induce reliance on that lie. Specific performance. To demonstrate entitlement to specific performance, a plaintiff must show as follows. 1. That the subject of the contract is unique. 2. That legal damages would not suffice to remedy any breach of the contract. 3. That the conditions triggering the defendant's performance have been met. 4. That there are no defenses to formation. And 5. That the court can reasonably enforce the order of specific performance. Temporary restraining order. To prevent this from happening, PAM should seek a temporary restraining order, TRO. The requirements of a TRO are as follows. 1. The plaintiff must show irreparable harm absent a TRO. 2. The plaintiff must demonstrate a likelihood of success on the merits. 3. The plaintiffs must demonstrate that the equities weigh in her favor against the defendant. And 4. The plaintiff must demonstrate that the TRO is in the public's best interest. A plaintiff should seek to notify the defendant that she is seeking a TRO, rather than proceed ex parte. If the plaintiff cannot reasonably contact the defendant first, she must certify to the court that she has made reasonable efforts to contact the defendant, or that she would be injured by contacting the defendant. Preliminary injunction. The requirements are similar to that of a TRO. The difference is that Dan must be given notice and an opportunity to be heard. Permanent injunction. The difference between the requirements for a preliminary injunction and a permanent injunction is that the plaintiff must actually succeed on the merits. Restitution. Restitution gives back a plaintiff the value she conferred on a defendant. Statute of Frauds. Under the common law, contracts for the conveyance of real property must be in writing, signed by the party to be charged, and must contain all essential terms of the deal. If this contract were governed by the UCC requires that any conveyance of goods for over $500 must also satisfy the Statute of Frauds. Exceptions to Statute of Frauds partial performance. However, there are some exceptions to the Statute of Frauds. 1 is partial performance. In a sale of real estate, courts usually require 2 of the following 3 types of partial performance: 1. Payment for the property, 2. Possession of the property, and 3. Making improvements to the property. Exceptions to the Statute of Frauds unique goods. There is an exception to the Statute of Frauds for unique goods. Here, the paintings were unique and the price paid for the goods supports a reasonable inference that Pam paid for 2 of the paintings. However, this exception to the Statute of Frauds typically only applies when the unique goods were manufactured for the buyer. Parole Evidence Rule. The Parole Evidence Rule, PER, bars any external evidence of the terms of the contract. For the PER to ban all external evidence, there must be a fully integrated writing. Where there is a partially integrated writing, courts will consider external evidence that supplements the contract. Courts usually make this determination with reference to the 4 corners of the agreement, asking whether the disputed term is one that would naturally be left out of the agreement. However, courts will consider evidence that the parties did not actually make a contract because there was no meeting of the minds, or that the contract as written does not conform to the mutual meeting of the minds. Thus, courts will consider evidence of fraud in the inducement of a contract, or unilateral mistake, because this is a defense to formation. That is, fraud and unilateral mistake are an argument that the contract is not valid as written because there was no meeting of the minds. Laches. The defense of laches applies when a plaintiff who seeks relief in equity has delayed bringing her cause of action in such a substantial fashion that it causes prejudice to the defendant.